This podcast is brought to you by Customplan Financial Advisors, Inc., an independent insurance managing general agency in Canada. Financialpodcast.ca was developed with one goal in mind: to educate Canadians on important topics that affect their financial well-being and make it readily available to all. We welcome you to plug in and learn with us. If you have questions, please email us at contact@financialpodcast.ca.
Good day, everyone, and welcome to Financial Podcast. I'm your host, Darlene, and we have a fascinating topic today: wealth strategy planning, changing the way Canada plans. One of the many goals of this podcast is to provide advisors with valuable tools of knowledge to better serve their clients. But sometimes the knowledge that is shared crosses a pretty broad spectrum. Estate planning is an integral part of maintaining and creating your wealth. It's an uncomfortable subject that many are happy to avoid. But with me today is John Askin, author of For Love, Not Money, founder of the Wealth Strategy Group. A former Albertan, he has both a commerce degree and a law degree, and he not only advises high net worth clients, but he also consults with clients and professional advisors in North America about wealth strategy planning. He is past president of the Estate Planning Council of Edmonton and a current member of the Vancouver Estate Planning Council and the Canadian Tax Foundation. And alongside his book, he's written numerous articles throughout Canada and in international publications as well. Phew! Welcome, John, to our show, and thank you for being here. That's an impressive background you have.
Well, thank you very much for the opportunity, Darlene. I'm really excited and looking forward to discussing some really important matters affecting so many Canadians and their advisors. And you know, as I discuss in my book, these are things that, for the most part, at least I find in my day-to-day working with people and with advisors, are just not being properly dealt with.
Yeah, I can see how that can happen, though. But in today's program, we'll talk primarily about estate planning. I did want to start in a little bit of a different direction, though. In your book, For Love, Not Money, you give people a really strong why for initiating a wealth strategy plan. Can you tell us what inspired you to write this book?
Yeah, it's a really, really good question, Darlene. So let me give you a few statistics. Over 50% of Canadians don't have a will. 80% of successful business owners have no plan to transition their business. Incapacity, for most Canadians, the likelihood of a significant long-term incapacity, is 8 times greater than premature death, yet very few people have done anything from a legal or financial perspective to deal with that. And according to the most recent statistics, over half of all existing marriages or common law relationships in Canada will break down. The bottom line, Darlene, is that from a planning perspective, the vast majority of folks have no long-term plan for if things go as they hope and expect, or if an unanticipated event occurs, whether that's premature death, incapacity, claim by a creditor, or most likely at all, according to the statistics, a matrimonial breakdown. So it was in response to those numbers and those significant unmet needs that I wrote what became ultimately my best-selling book, For Love, Not Money, and prompted me to found the Wealth Strategy Group. And just to set a context for what we do is we govern ourselves from the following mission statement. I want to control my property while I am alive, take care of me and my loved ones if I become disabled, and have total control over my assets, that they go to who I want, when I want, and how I want, saving the most I can in taxes and professional fees along the way.
Wow, that's quite a mission statement. It's quite a mission. It's shocking, the statistics that you've just given us. I honestly had no idea, but it's not something you really talk about. Insurance can be kind of and wealth strategy planning, estate planning, it can be all kind of uncomfortable subjects. But for those listeners like me that aren't in the financial services industry, can you tell us what is the difference between a wealth strategy plan and an estate plan?
Well, traditional estate planning has tended to focus on death and dying. However, in our experience, most people we talk to, at least, are far more interested in planning for living, not dying. And that's the focus of our approach, is planning for living, not dying. We'll deal with death and dying, but as you've seen from those statistics I just gave you, there are likely many other significant events that we have to plan for before we ever get to the end game.
Wow, okay. Estate planning can seem like a really daunting task. And in preparation for this program today, my husband, he lent me a couple of his books on wealth planning and estate planning, and they're huge. And so I can see why some people might resist doing this. Is there a way to simplify this process?
Well, interestingly, Darlene, I'm going to come at this a little bit differently. And I'm going to say that simplifying the process is actually one of the main answers to the question why so many Canadians haven't done anything. We, as advisors, have made it way too complicated. And it's one of the main reasons people don't do anything. They get so confronted. And again, most advisors, most conferences you go to, seminars, things you read, books you pick up, like the one you just alluded to, are all talking, everybody's talking about how. This is how we're going to do this. This is how we're going to do that. But the reality is, people want to know why before they care about how. They need to understand why. And there's far too little conversation and emphasis on why they should be doing certain things from a planning perspective, as opposed to the how to. It's not that the how is not important, but we're not talking enough about why. And I like to talk about context. The context for 99% of books you pick up on estate planning, 99% of seminars you go to and people you hear speak, they're all talking about how to do this and how to do that. The context for what we do, the Wealth Strategy Group, and the context for my book, it's not about how. And you can see this because I know you've got a copy and you've looked at it. The context for my book and why I wrote it is why. It's a call to action. We need to do something about those statistics. We need to get people planning for these significant events, both during their lifetime and afterwards. And it's not being done. And those numbers, by the way, haven't changed in the last 25 years. They're not getting any better. I have studies from 25 years ago and studies from a year ago, and the numbers are the same. So we need to start talking to people about why versus how. And we need to, from a financial literacy perspective, we need to be talking about how we can simplify that process for them so that it makes sense. Because again, people don't care how until they know why.
You know, I think that philosophy can be related to many different areas in life. Like if you don't have a strong why to do something, it's really hard to find motivation to get that thing done. And when you look at something like estate planning, it can seem even a little scarier because it could be, you know, so much more complex. There's so many things to consider. And so I think you're right. You know, it's important to simplify the process so that people will understand. But for you listeners out there, if you do pick up the book, you'll see throughout the book, John regularly mentions that, you know, this is a good why, because if you don't plan for it now, somebody else is going to make that decision for you later after you're dead when you have no say in the matter.
Absolutely, Darlene. And, you know, Mark Twain said that the hardest part of the journey is always the first step. And we as advisors need to take responsibility for making it as easy as possible for Canadians to take the first step. Because once they can take that first step, then they see, oh, okay, I got a little bit of traction here. Now I can do this. Now I can do this. Now I can do this. But if they just sort of look at the whole thing, and like you say, it was the perfect example you cited earlier. You pick up this book and like, you're not even going to open it. You see, you're lost immediately and somehow without ever addressing the why.
Yeah, it can be. So I'm thinking it can probably be as simple or as complex as you want it to be, but you just have to get that first step.
Absolutely.
So you mentioned about the significance of planning for unanticipated events. What are those and why are they important?
Yeah, and this is primarily directed, Darlene, about planning for living, not dying. I'm going to preface all these with that because these are ones that are much more likely to happen during a person's lifetime. And by doing some planning ahead of time, you can achieve a far better result. So I'm just going to go through a few of these. First of all, let's talk about incapacity. The reality is, again, statistically, for most of us, we have an 8 times greater risk of a significant long-term incapacity than premature death. I'm going to say that again, 8 times greater probability that you and I will incur a significant long-term incapacity before we die. 1 in 2 Canadians, coronary heart disease, 1 in 3 life-threatening cancer, 1 in 4 stroke or stroke-related illness. Then there's 2 aspects to planning, and those are just, I could go on and give you a lot more statistics, but those are pretty salient ones to start with in terms of what's the probability of this happening. It's like, wow, I didn't know that. And there's 2 fundamental aspects in planning for incapacity. There's the legal aspect, which is represented by things like enduring powers of attorney, advanced healthcare directives, representation agreements. And the second aspect are the financial aspects, which can often be addressed through insurance products like disability insurance, critical illness insurance, long-term care insurance. So that's incapacity. Now, the second unanticipated event is, and this is one that again, most people are not talking about when they do planning, and that's claims by creditors. Especially if you're a business owner, and I believe from what you told me, there's going to be some financial advisors listening to this podcast as well. If you're a financial advisor, you have unlimited, indefinite liability exposure. And it's significant. That doesn't matter whether you incorporate or what you try to do or not do with it. You cannot get rid of or abdicate from that liability exposure. And very importantly, for professional advisors, and this is, we work with a lot of senior advisors who are retiring or leaving, transitioning out of their practice. They need to understand that it goes on indefinitely and probably even survives death, according to recent case law. We've seen situations with advisors know the business for 10 years and get sued. And most advisors are not even aware of that. And knowledge is power here. By becoming aware of that, then we can initiate some planning to take care of it. But if they're not even aware of it and don't do anything, that's when the problem arises. So, and I'm just, I could go on all afternoon talking about that one, but basically where we want to get people to, whether it's individuals, business owners, financial advisors, is to a place of, and I talk about this in my book, own nothing, control everything.
Yeah. Yeah, you've got that throughout the book.
Own nothing, control everything. It's very powerful, but you have to do this ahead of time. Sorry, go ahead.
No, I was just going to say it's one of those statements where you have to pause and think about it, the impact of actually doing that and why that's necessary. So,
and if you think about our industry, the insurance industry, again, some more statistics. The reality is that 80% of the business is controlled by 20% of the most senior advisors. And the vast majority of those advisors are going to be leaving the business in the next 5 to 10 years. And almost none of them have done anything to set themselves up for that, Darlene. And, it really is a classic example of the shoemaker's kids have no shoes. These advisors have been advising clients during their whole, period in the business to do planning, do this, do that. They haven't done it for themselves. They haven't done it.
But, exactly. The Shoemaker's Children is an excellent example. And it surprises me. Actually, before you mentioned that, I would have never even thought that is something a financial advisor would want to make sure that they've got in place. So this is an eye-opening conversation for me, that's for sure. But in your book, sorry, go ahead.
I was just going to say, we do a lot of work with senior and junior financial advisors in terms of facilitating transition programs to ease the senior advisor out of the business in a way that it can maximize their value, minimize the tax liability, and very importantly, minimize the potential professional liability going forward, and at the same time, give junior advisors coming into the business or that have been in the business a few years the opportunity to acquire very valuable practices. And by marrying those two together, very, very much better results can be obtained than what with no planning happens.
Well, and it better serves their clients too, right? Because if there is a smooth transition from one advisor to another, the clients that are involved in that are going to be served better.
Nobody wins when a client is orphaned. Not the client, not the original advisor who had the client, and not any new advisor who picks it up. Everybody loses, and even the supplier companies, everybody loses when a client, and the reality is that's a pandemic. That is a pandemic that's happening in the financial services industry right now, our orphan clients. Why? Because the transitioning advisors who are leaving the business don't have a plan in place to facilitate a transition whereby their clients are taken care of.
It's a good wake-up call then today.
Well, again, I've been preaching this message for a long time, so anybody who will listen, I'll talk to them about it.
Something else you mention in your book is reliance on a traditional will-based estate plan, and this can present significant problems. What are some of those problems that could be presented?
Well, and again, this goes back to your earlier question, what's the difference between the traditional estate planning model and our wealth strategy planning model? We do not work from reliance on a will-based plan. And by the way, I have to preface all these comments and with the fact that I'm not saying that people shouldn't have a will. Everybody still needs a will. You need a will to appoint a personal representative to manage affairs after you're gone. You need a will to appoint letters of guardianship for minor children. You need a will for a whole bunch of administrative type things. But as a vehicle to transfer any significant wealth or assets, wills don't work. And that's what I'm going to talk about. But I needed to say that first, because some people go away from one of my presentations and say, oh, geez, I scrap my will. No, that's not what I'm saying. You still need a will, but don't use it as the primary vehicle to transfer any significant wealth or assets. And I'm going to talk about why now wills don't work in response to your question. First of all, are challenges. And in my book, I use the phrase at the beginning of the chapter on problems with wills, that wherever there's a will, there's a relative. And this is booming business for lawyers and law firms, challenges to wills as our society is aging. And there's a lot of wealth. In fact, another statistic, it's forecast that in Canada over the next 10 to 15 years, $1 to $3 trillion of wealth is going to change hands. That's a once in history of event. That's not once in a generation. We've never seen anything like the magnitude of this wealth transfer going on. And I'm going to tell you that all the rules change as soon as somebody's gone. Everything's fine when the parent's alive and people may even be getting along. But as soon as that parent is gone, it's a whole new dynamic. And it battles over estates, and estate litigation becomes the battleground in which latent, festering family feuds get played out. It pits mother against daughter, brother against sister. It's ugly, it's vicious. We've seen so much of it with clients over the years that it tears families apart. And this easily rivals, for anybody that's listening that's gone through a child custody litigious scenario, this easily rivals that, except you have 50 and 60-year-olds that are basically fighting as 4-year-olds. And it may start out to be about the money or the property, but it really isn't. And it's I can't tell you how many times I've heard some version from a client, some version of, I would sooner see every last dollar of this estate go to pay your fees than that SOB get another dime. And all you have to do is ask somebody that's been involved in estate litigation, and they will validate that. When I do my presentations, there's always a few people in the room, and God bless them, one person, brave soul, puts his or her hand up and says, "Yep, that's exactly what happens. It's terrible." So that's the context for challenges to wills. And again, the basis for all of these problems with the will-based plan is that up until the point of death, a will doesn't have any legal effect, if you think about it. You or I do a will, we're alive, we can change it, we can amend it. It doesn't have any binding legal effect, but at the moment of death, this critically important planning document, the legal impact becomes crystallized. And the person who drafted that will does not have any opportunity to change it, clarify it, or correct any errors in it. And all of these issues come out of that fundamental fact about reliance on a will-based plan. So how do we challenge wills? Well, there's several ways that wills can and often are challenged. And the first one is and this is, I call it technical irregularity or non-compliance with the Wills Act or whatever the wills legislation is in the relevant province. Wills are a creature of provincial legislation. And for example, so what that means is that if there is any technical non-compliance with any of the provisions in the Wills Act, then a will can be and is often challenged. Second, even if a will is technically valid, ambiguity of the wording is another fruitful ground for challenging wills. And if you think about that, when this planning document becomes relevant and becomes legally enforceable, the person who drafted it's no longer there. They can't stand up in front of the judge and clarify, although this is what I meant. And even the simplest monosyllabic words, Darlene, like spouse. Well, does that mean that their spouse at the time you drafted the will? Could it be the spouse at the time you died? All of them? Child. I can't tell you how much litigation we've seen with illegitimate children, claims by illegitimate children. Here's another one.
Key. Holy cow.
Yeah, and you don't have any opportunity to fix it.
No, that's right. Sorry, I interrupted you.
No, that's fine. That's I'm just I'll keep going here. So technical irregularity, ambiguity of wording. Third way to challenge a will is even if it's technically valid and the wording's clear, it's still open for a person to allege that at the time you, as we call them the testator, the person who's died, at the time the testator drafted this critically important planning document, they did not have the requisite degree of mental capacity such that they understood the full nature and consequences of their actions. That's the legal test. And again, you're not there. You're probably in a hole in the ground with dirt in your face or in an urn on a mantle or someplace, but you can't say, I knew what I was doing.
I was just going to say there's many a movie based on that premise alone.
And those movies are often based in reality for sure. And carrying on from that, other ways of challenging will, even if capacity is established, it's still open for someone to allege, oh, well, that particular child or that person, whoever it might be, was exerting undue influence over the free mind and will of the testator such that this was not a valid expression of their true intentions and wishes.
I can see that happening, yeah.
And even if the will survives all those challenges, at the end of the day, in every province in Canada and every jurisdiction in the United States, there is in one form or another wills variation legislation that judicially empowers judges to rewrite the terms of an otherwise valid will in any manner they see fit if a claimant is able to satisfy the judge on that particular day that there was not adequate provision made for the proper maintenance and support of that person. That's the legal test. And again, lawyers have to eat too. And so people come into a lawyer's office and say, this will is not fair. So-and-so got this and so-and-so got that. We want to challenge the will. Lawyers are very creative and they're highly skilled and trained, as you probably know, in coming up with and crafting legal arguments as to advance the interest of the person who's paying their bill. I can tell you statistically, again, there was more money spent last year on funding estate litigation than on personal injury claims. It's a booming business for lawyers and law firms.
Wow. You know what? You hear that and then you think, is that really true? And I guess it is.
I was speaking recently at a conference in Kelowna in the interior. We're talking about this, and this lady put up her hand, and she was an elderly lady, and she said, you know what, I'm going to just share with you quickly. She said the story. My sister passed away recently, and I was appointed the executor. And she said this estate was not large. I think she said it was, I don't know, $500,000 or $750,000, which in today's terms, if you own a house, your estate's probably that big, depending on where you are. And she said, it's been a week since my sister passed away, and I've been named the executive. We just had the funeral, we just buried. And she said, I've already now received registered letters from my other two sisters advising me that they're contesting the terms of that will. So it's not about how much. As I said, that's the red herring. You don't need a lot of money to encounter challenges to wills. It's the battleground in which latent family feuds get played out.
Well, there's a lot of emotion involved, right? So that's probably what a lot of that comes down to. But like you said, we could probably spend hours talking about that alone. So
there are other issues, though. If I don't know if you want me to go on, there's several other issues involved with reliance on a will-based plan besides challenges. That just talks about the first primary issue, but other issues include, confidentiality. And it's an interesting phenomenon. We find that so many people we deal with, they're very concerned about confidentiality. They don't want anybody to know how much they owe or how much they own or anything like that. I know you may know somebody like that. However, to the extent you've relied on a will-based plan, everything you own, everything you owe becomes a matter of public record. And any member of the public is able to access that for whatever the search fees are now at the surrogate court registry of maybe $10 or $15. You can find all this stuff out. So there's absolutely no confidentiality with reliance. And that feeds into the estate litigation. And in fact, coming back to the part about litigation, under the various wills legislation and estate administration legislation in our provinces, there's a requirement that there must be a public notice published in newspapers circulated within the jurisdiction the testator was domiciled at death, advising people that so-and-so of this location has recently demised, and should anyone be wishing to advance a claim against the estate, they must do so within a certain period of time or they're barred by the statute. So there's a public invitation to challenge these things. That's another issue, is confidentiality. There's a third issue with jurisdictional issues. And this is one that it just doesn't get talked about. And again, as you recall, when I said that wills are a creature of local legislation. So what that means is that a will could be valid in Alberta, for example, and not valid in BC because of the differences in the wills legislation between the two jurisdictions. A common example is something called holograph wills, where something wholly in the handwriting of the deceased, signed and dated at the end, is recognized as a valid will in some places, but not others. So where that becomes important is people often own property, real estate, in multiple jurisdictions. So their will in one jurisdiction saying, okay, it's valid in that jurisdiction, I'm going to leave that real estate to so-and-so, may not be valid in another jurisdiction where the property is located. That's a big issue. And now we get into property in the U.S., property in other parts of the world. It really gets complicated. And of course, lawyers will often advise people in interjurisdictions, you have to execute another will in that jurisdiction. Well, the problem with that is you just compounded the problem. So now we got 2 wills or 3 wills, and we see some people come into our offices. The wills aren't saying the same thing.
Oh, no.
And that happens all the time. So the final thing, just if I can, to talk about issues involved with reliance on a will-based plan is that wills guarantee probate, and probate guarantees probate fees. Now, for anyone that's been involved in administration of an estate, they know that probate, which is the legal name given to the processing and validating of a will and then distribution of assets, payment of liabilities, can be a very complicated, time-consuming, and expensive process in and of itself. But very importantly is our probate fees. And for example, it wasn't that long ago in BC, probate fees increased 130%. And this is a straight tax, by the way. Nobody does anything for this. It's basically what's the value of the asset you own at death, you apply the rate and pay the tax. So they increased 130% in BC. They tripled in Ontario. And there was a little article, I remember, page, I think 7 or 8 of the Vancouver Sun at the time, saying probate fees increased 130% in BC. Nobody cares. Because it's not being paid until this future point in time, most folks are not concerned about it. But to the extent you've relied on a will-based plan, you will become subject to probate and probate fees. And by the way, another thing to say about that is, and anybody that's been following the news recently can see that our federal government is committed to paying down this massive deficit that we're incurring. And I'm not, by the way, in any way, shape, or form saying that they shouldn't be spending what they're doing. I mean, I think there's a lot of great programs and things they need to do because of this COVID emergency. However, at some point in time, somebody's got to pay for all this. And it's clear, and it's been said, and they're on the record with it, with the finance minister, with our prime minister, that the repayment of this deficit is going to be put on the backs of wealthy Canadians. And I can tell you, because we know a lot of people in Ottawa, that the Department of Finance is right now working on a proposal for a new wealth transfer tax. So I think you're going to see a national estate tax come back into play. People don't realize we did have estate taxes before tax reform in 1971, and then they were done away with after the Carter Commission report, and we rewrote the Income Tax Act. So the federal government's going to get into the wealth transfer tax area in the near future. And to sum that up, and then I'll let you go on with the next question, Darlene. But the advisor, the finance advisor to King Louis XIV, said it the best: the true art of taxation is the ability to pluck the most feathers from the gander with the least amount of squawking. What better gander to pluck than the one that's dead? It's the most politically saleable tax. There's $1 to $3 trillion of wealth that's going to change hands. The government knows this. They're going to go after it. And that's one of the ways they're going to go after it, is a new wealth transfer tax.
Wow. That's kind of scary and disturbing. And, for me, that's the first I've heard of it. But it'll be interesting to see, when that should happen, if it does. But holy cow, you brought up a lot of good points, and I hope our listeners were taking notes, because, you talk a lot, you brought up a lot of good points about the pitfalls of having a wills-based estate plan only. And I think you've given a lot of people a lot of food for thought. But to go on, perhaps, for somebody that's new to the insurance industry, what training should they consider if they want to follow in your footsteps and specialize in estate planning?
What I do a lot of work training advisors, junior advisors, senior advisors, and a lot of presentations, Darlene. And one of the messages I convey to folks along the way is that, especially when you're coming into the business, you have a fundamental choice, I believe. You can either become a technical expert and focus on understanding all the nuances of tax and estate law and insurance law and all those things, and then partner with people who need that kind of support. Or you could become an expert in finding prospective clients and managing relationships. And then in turn, that person would partner with technical experts to support them. The key point and my main message to advisors is to take a hard look and decide, do what you do best and are passionate about, and delegate the rest. And partner with other professionals who do what you don't want to do to create win-win relationships. Don't try to do this all yourself. In my experience, it's not possible. If we look at income tax legislation or law, just as an example, between technical amendments, press releases, budget announcements, advance rulings, court cases. The law is changing pretty much on a daily basis. It's not possible. It's not possible for one person even to keep up to breast on all that's going on in the tax area. Never mind everything else you need to focus on. So fundamentally, I think people just need to make a choice early on in their careers. What do I want to do? Do I want to become a finder and manager of relationships? Incredibly valuable. Nothing starts till we get the client. Or do I want to become the technical expert that supports the people who do that, and then we partner?
You know what? That's good advice, again, for general in life. And we were talking to a fellow who was educating our listeners on how to build a business. And he also mentioned having, a lot of good team players and, not being afraid to bring in somebody who is an expert in a particular area, because they'll again service the client better. So, there's a lot of consistent advice I'm hearing in this industry, and that's good.
I think the simple way of saying it is pick the lane you want to swim in and stay in your lane.
Yeah, I think that's, once again, excellent advice. So for somebody, again, that is new to the industry, if they have a client that they feel could benefit from a discussion on estate planning, what would be their best course of action?
Well, assuming that they don't have the necessary competence or expertise to do it themselves, then it just follows from the question you just asked to find someone, partner with someone who has that expertise. We do that all the time in the Wealth Strategy Group. We have across Canada, across North America, and even internationally, we have all kinds of folks that we partner with to bring in the necessary horsepower to address specific needs that an individual client situation has.
Right. Consistent. I like hearing that message. So what role does insurance play in estate planning?
That's a really, really good question. I think that from our perspective, Darlene, the primary role is managing risk in a financially effective manner. And there's two main types of insurance products. There's life insurance, which the way we look at it addresses two fundamental risks of either dying too soon or living too long. And then there's incapacity insurance, which addresses three risks. There's disability insurance, representing loss of income if you're not able to continue working. Critical illness insurance that, irrespective of loss in income, pays a lump sum to offset maybe medical costs or something of that nature. And I think critical illness insurance is actually a really good example of insurance product that can save your life. We've had many situations with clients where they've had critical illness policies. They've had a diagnosis. A client recently had a diagnosis of triple bypass surgery that he needed. And that was the bad news. And it got worse when he was told the waiting list in BC was going to be maybe 9 or 10 months at least, because his situation wasn't an emergency. And he said to me, I'm going to die from the stress waiting for this. He had I believe it was $150,000 payout within 30 days on a critical illness policy, and had his open heart surgery done 2 weeks after that at the Arizona Heart Institute. So again, it's an example of insurance that can save your life. And then the third area of incapacity insurance is long-term care.
Yeah, which has become really important, especially, over the last year. It's come up in conversations more often, I would think.
Well, absolutely. And I think that for the most part, you'll get what you pay for, at least what we've seen. And, to get the proper care in a protected, safe facility, you easily can be looking at $10,000 to $12,000 a month.
Wow.
Who's going to pay for that?
Exactly. So going off course here a little bit, I see these all over the place in so many different stores, but what is your opinion of these widely available will kits that are out there?
Well, the first thing I'm going to say, and I'm kind of laughing as you bring that up, Darlene, the first thing I'd say about will kits is look at the people that are marketing those. They're primarily lawyers and law firms. and they make work projects for lawyers and law firms. Why? Because they are one of the main sources of litigation. People that pick these things up, and we've seen people with $10, $20 million estates they wanted to save a few $100s to go to a lawyer even and get a will done, never mind any other planning. But they went to the stationery store, picked up this will kit, and it was executed improperly, or they missed something, or technical non-compliance, or ambiguity of wording. And remember, wherever there's a will, there's a relative. So they're a make work project. So I said, for lawyers and law firms. And, again, this is where we're going. That more money spent every year on this legal fees for estate litigation than personal injury claims. It's booming business for lawyers and law firms. That's my view on will kits. First of all, you shouldn't be relying on a will to transfer significant property. And second, if you are, for God's sakes, get proper advice. This is not a do-it-yourself project. This is really not a do-it-yourself project.
And they seem to follow, a one-size-fits-all sort of solution, and that's not the case. One person's $1 million estate is not going to be the same as another person's $1 million estate. Assets could be so entirely different. So.
Well, exactly. And you run into potential jurisdictional issues that I talked about previously. You're going to have probate and probate fees. And again, wherever there's a will, there's a relative. And I'll tell you what, a do-it-yourself will is probably one of the best and most fruitful grounds for someone challenging that document.
So speaking of documents and tools in estate planning, so maybe you can briefly tell us that besides wills and powers of attorney, are there any other tools that can be used in estate planning? Yes. And, we see this so often, Darlene, that first of all, people don't even have enduring powers of attorney. They may have a will, but they don't have an enduring power of attorney. And then the next companion document that so often is non-existent is an advance healthcare directive or representation agreement. And what that is you see, an enduring power of attorney typically only applies to financial assets and financial affairs. Who is going to have authority to make healthcare decisions on your behalf if you're not able to because you lack capacity, either because of disease, illness, drugs, dementia, whatever it is? And if you don't ahead of time set that up in a legal document, then doctors and families they start fighting over it. Who gets to say if we can pull the plug? Who makes that decision? And this is why it's so important. Even if you could easily take the position that, well, who cares? I'm dying anyway. I don't care. But really, if you have people in your life that you care about and love, why are you setting them up for fighting about things? Why not make it easy for the people you care about? So the ability to predetermine who has authority to make healthcare decisions is separate and apart from a power of attorney. And depending which jurisdiction you're in, it's some form of advanced healthcare directive or representation agreement. So that's certainly one of the first tools that we often see is missed in the planning process. And then beyond that, we get into, okay, this is now we're talking about, because this the burning question in the background all the way along here. Okay, I've got all these problems with wills, etc. Well, what can we do to avoid some of those problems? And that's where we can now get into things like living trusts. And there are many varieties of living trusts. There are family trusts. There are joint partner and alter ego trusts, which are fairly recent developments in Canada and can greatly assist older Canadians. You have to be over 65 to use those, to avoid many of the problems previously discussed associated with reliance on wills. You can actually get around the vast majority of those problems by using alter ego or joint partner trust. And so having these living trusts, that overcomes some of the challenges of jurisdictional issues, clarity issues. That's where this would come into play?
Yes, because it's not a will. The advantage of a living trust is it's living. It's not legally effective when you die. It's done ahead of time while you're alive, healthy, and in control. So it's all predetermined. So you really do minimize all of those issues we talked about earlier. It doesn't go through probate. Don't have probate fees. Probably not subject to a wealth transfer tax if that's going to apply on death, because it's predetermined. So you want to predetermine it before you die. Another example of that, of course, is you have joint ownership, joint property arrangement, shared ownership. agreements whereby ahead of time, for example, you have two people on title to a property, and it's a joint tenancy such that on the death of one of them, the property automatically transfers by operation of law to the surviving joint tenant. Doesn't go through probate. Now, there's a whole bunch of problems with those. They have their own problems, and you have to do this right. And again, as always, you want to get proper advice in setting those things up. And of course, finally, we've already talked about the use of life and incapacity insurance to address many of the issues. Life insurance, if you have a named beneficiary, doesn't go through probate. It's not challenged. It's not challengeable in the same way that a will is, and is credit approved. There's all kinds of really significant benefits beyond just the money, beyond just the liquidity. There are many other significant legal benefits associated with insurance policies that are properly structured that most people aren't even talking about.
That's probably a whole other conversation on its own.
All of these are, Darcy. Like I said, pick any one of these and we can go on for most of the day about it.
Oh, I've no doubt it's, you've taken something that could be complex and you've simplified it and given people a really strong reason as to why they want to do this. So, John, you know what? Thank you again for joining us today. And it's been an enlightening conversation. John's book, For Love, Not Money, is the kind of book that can reach out to many people. It's informative, but not a lengthy read. And I encourage everyone to get a copy. So, John, I'm going to hand it back to you. Is there anything you want to say in closing?
No, just thank you, Darlene, for the opportunity to get this message out to as many people as we can. That's my personal mission, is to make a difference with as many people as possible, to enlighten them in a hopefully simple way, and a way that comes from why we should be doing something versus getting bogged down in the technical aspects of how. And so I very much appreciate that opportunity.
You're very welcome. It's been educational for me. And I've always believed that once you discover your why, the how works itself out.
Yeah, I couldn't agree with you more. And just to add on to what you were saying, if people want to get a copy of my book or even contact me directly, they can certainly do that at wealthstrategy.ca, or you could even send me an email. It's taxwiz, taxwiz @shaw.ca.
Excellent. And we'll have all of that contact information on the website when this podcast goes live. And you will be able to get in touch with John at your leisure. Well, thank you again, John, for joining us today. And I hope you have a fabulous rest of your day.
Thank you so much, Darlene, and be safe, be well.
Thank you. You too. Bye-bye.
The views expressed here are those of the participants and not those of Customplan Financial Advisors, Inc., its affiliates, or subsidiaries. This is not intended to serve as a complete analysis of every material fact regarding any company, industry, or security. This presentation may contain forward-looking statements. Investors are cautioned not to place undue reliance on such statements, as actual results could vary. This site and podcasts are for general information purposes only and does not constitute investment advice and is not intended as an endorsement of any specific investment product or service. Individual investors should consult with an investment professional about their personal situation. Past performance is not indicative of future results. If you are unsure about what is the best course of action for you in your financial planning, then we suggest you consult a fee-based independent financial advisor or get in touch with us to discuss your individual situation. Our phone number is 604-687-7773.